Good morning. Are you Harold Middleton?
Yes.
All right. So this is People v. Harold Middleton, file 25-70550FH for arraignment. Counsel, you want to state your appearances, please?
Anthony Julie on behalf of the people.
No, not Gauthier for Mr. Middleton, who appears remotely from the Chippewa County Jail.
Okay. Have you had a chance to review the charging document with your client?
I have, Your Honor. He did not want to waive any sort of formalities or readings. At this time, he wants a formal arraignment conducted.
No problem. All right. Mr. Middleton, are you Harold Stanley Middleton III?
Yes.
All right, Mr. Middleton, you are charged in a felony information with 3 counts as well as a habitual 4th notice. In count 1, breaking and entering a building with intent. It alleges that on or about May 6th, 2024, in the village of Wolverine, Cheboygan County, that you did break and enter a garage located at 5734 Cedar Street, Wolverine, Michigan, 49799. With the intent to commit the crime of larceny therein. That would be a felony punishable by a maximum of 10 years in prison. The prosecutor has filed a notice that you have been previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about April 19th, 2022, you were convicted of possession of methamphetamine in the 50th Circuit Court for Chippewa County, state of Michigan, and on or about April 19th, 2022, convicted of malicious destruction of fire or police property, again in Chippewa County, state of Michigan. And on or about April 23rd, 2024, you were convicted of maintaining a drug house in the 50th Circuit Court, again for Chippewa County, state of Michigan. With that habitual offender notice, that would increase in the court's discretion the maximum penalty for the B&E on count 1 from 10 years to a maximum of life in prison. Count 2, larceny, $1,000 or more, but less than $20,000, alleges that on or about the same date and location as in count 1, you did commit the offense of larceny by stealing a 2010 Ford F-150 that belonged to a Lance Michael Harmer. The value of the property stolen was $1,000 or less, $1,000 or more, but less than $20,000. That would be a felony punishable by a maximum of 5 years and or $10,000 fine, or 3 times the value of the property stolen, whichever is greater. However, with the habitual 4th notice, that would again increase the maximum penalty in the court's discretion to life in prison. Count 3, motor vehicle unlawful driving away, alleges that on or about the same date and time as counts 1 and 2, and at the same location, you did willfully and without authority take possession of and drive or take away, or did assist in or was a party to such taking, possession, driving, or taking away of a motor vehicle, to wit, a 2010 Ford F-150 belonging to another, to wit, Lance Michael Harmer. That's a felony punishable by a maximum of 5 years in prison and a suspension of your driver's license by the Secretary of State. But again, with the habitual 4th notice, in the court's discretion, the maximum penalty could be increased to life in prison. Mr. Middleton, do you understand the maximum penalty of the charges against you, or do you have any questions for me or your lawyer about them?
No, I understand.
Okay, and Mr. Nightingale, how does Mr. Middleton wish to plead to those?
Not guilty.
Cases? Okay, we'll enter a plea of not guilty, Mr. Middleton, as to all 3 counts, and Mr. Nightingale is a forensic center referral requested.
No, Your Honor.
What would be the estimated length of trial?
I would say 2 days.
Okay. And I did see there was a preliminary examination in this matter, and a transcript prepared. Are you anticipating motion to quash?
I am, Your Honor. I will file it as soon as I can get it drafted.
Okay, we can set this then for a docket call, and you can notice up a motion to quash on September 30th at 10:30 a.m. And is Mr. Middleton expected to still be in the Chippewa County Jail at that time?
He will be in the jail still at that time, yes.
Okay, we'll have that be a Zoom appearance on his part. Anything further from the defense?
No, Your Honor. Thank you.
Anything further from the people?
No, thank you.
Okay, Mr. Middleton, your lawyer's going to file a motion challenging at least 1 or more of the charges up here. And we're going to hear that motion and have you zoom in on September 30th at 10:30
Okay,
in the
but
morning,
I
right?
would like to be there. I could,
You'd like to be there in person?
yeah,
All right, well, I'll have you talk with Mr. Nightingale about that between now and then. I think it's not required that I would have you be in person for that, since it's just some legal arguments. But if he wants to make that request, I'll discuss that with him and the prosecutor beforehand. All right, otherwise we'll
Right.
probably have you zoom in. I'll see you then, sir.
and I would like my discovery pack as also.
Okay, Mr. Nightingale, have you been provided with discovery?
Yes, Your Honor.
I would
Mr.
like
Middleton,
my
it should be on the way to you.
transcripts from my
I think it got
prelims,
mailed
too.
out late last week.
So, Mr. Middleton, when you're represented by an attorney, then the prosecutor doesn't present it to you directly. They give it to your lawyer. He's indicated he has it and he's getting a copy out to you. Anything else?
No, just waiting on my discovery pack that I've been waiting on for a while now.
Okay.
I mean, it
All
is
right,
my
well, you
right to
should-
have it, so,
Yep, and your lawyer's got it and he says that it's on its way to you.
okay. I would like
All right,
my
let's
other,
see.
my transcript for my preliminary exam too. I'd like all that too.
Okay. Well, again, that's stuff you'd request from your lawyer, not from me. He's got it
And
and
I've
he's
been
representing
requesting.
your interests. Okay. All right, you have a good day, sir.
Yep.